Hello, good people. Welcome to New Justice Media, hosted by the Media Mike Speaks. All right, good people. The impact of the Supreme Court's decision on New York gun rights. Now, the U.S. Supreme Court, they did a double header. Two decisions in what, 1 week or 2 days of each other? Amazing. So let's talk about this gun rights. So my other channel, the Media Mike Speaks, good people, had a strike against it, talking about, there's some medical, anyway. But that'll be back up and back on by next week, by next Thursday. So look out for that. And right now, this is my backup channel, New Justice Media and the Hot Mike Speaks. So go ahead and subscribe to this one and the other one, the Hot Mike Speaks also. Look for the Flaming Mike. Look for the scales on this one, the scales of justice. So let's get to this story, good people. The Supreme Court ruled Thursday that the Constitution provides a right to carry a gun outside the home, issuing a major decision on the meaning of the Second Amendment. The 6-3 ruling, they're still on 6-3. They were 6-3 with the abortion, now they're 6-3 with this one, was the court's second important decision on the right to keep and bear arms. In a landmark 2008 decision, the court had said for the first time that the amendment safeguards a person's right to possess firearms, although the decision was limited to keeping guns at home for self-defense. The court has now taken that ruling to the next step after years of ducking the issue and applied the Second Amendment beyond the limits of homeowners' property in a decision that could affect the ability of state and local governments to impose a wide variety of firearms regulations. Well, it said the right to keep and bear arms, to bear arms, which the Second Amendment states. The decision, which came as Congress advanced the most significant gun violence prevention legislation in almost 30 years, involved a New York law that required showing a special need to get a permit to carry a concealed handgun in public. The state bans carrying handguns openly, but allows residents to apply for a license to carry them concealed. The law at issue said, however, that permits could be granted only to applicants who demonstrated some special need, a requirement that went beyond a general desire for self-protection. And what would that need be? Now, I used to live in New York State. I spent 2 years up there. They have some of the strictest gun laws in the country besides California. Now, California used to be lax back in the 70s, but you know how that thing went with the Black Panthers, and they squashed that. So anyway, the law at issue said, however, that permits could be granted only to applicants who demonstrated some special need. Now, we don't know what that is. Now, gun owners in the state sued, contending that the requirement made it virtually impossible for ordinary citizens to get the necessary license, which I agree. They argued that the law turned the Second Amendment into a limited privilege, not a constitutional right. I agree with those citizens who did sue. The court agreed with the challengers and struck down the heightened requirement, but it left the door open to allowing states to impose limits on the carrying of guns. The constitutional right to bear arms in public for self-defense is not a second-class right, subject to an entirely different body of rules than the other Bill of Rights guarantees. Justice Clarence Thomas wrote in the majority opinion, "We know of no other constitutional right that an individual may exercise only after demonstrating to government officers some special need," unquote. And I agree with Justice Thomas on that. It's not a second-class right. It's a first-class right. It's a citizen right. In the ruling's most far-reaching language, Thomas said concern for public safety isn't enough to justify new gun controls. The government must affirmatively prove that its firearm regulation is part of the historical tradition that delimits the outer bounds of the right to keep and bear arms, he wrote. In a concurring opinion joined by Chief Justice John Roberts, Justice Brett Kavanaugh said the ruling does not bar states from imposing licensing requirements for carrying handguns for self-defense, such as fingerprinting, background checks, and mental health records checks. Of course not. New York's law was problematic because it grants open-ended discretion to licensing officials, like the police, and authorizes license only for those applicants who can show some special need apart from self-defense, in effect denying citizens the right to carry a gun to protect themselves, he wrote. However, it was not met without its opposition. But in New York State, armed security officers can carry a firearm only on the job. After that, they must turn it in. They can't take it home. They must turn the weapon in and pick it back up when they post on duty. Now, cops, firemen, I think in New York State can carry the weapon. District attorneys, yes. Special prosecutors, yes. But not law-abiding citizens openly outside. At their home, yes. So let's listen, take a read here to the opposition. New York's Democratic Governor Kathy Hochul responded to the ruling Thursday, first tweeting, "It's outrageous that a moment of national reckoning on gun violence. The Supreme Court has recklessly struck down a New York law that limits those who can carry concealed weapons," unquote. In response to this ruling, we are closely reviewing our options, including calling a special session of the legislature. Just as we swiftly pass nation-leading gun reform legislation, I will continue to do everything in my power to keep New Yorkers safe from gun violence, she said. Okay, you mean from the criminals who actually have the guns, most likely illegally. At an event celebrating a new law to enhance school safety in the state, Hochul also called on Congress to strengthen federal gun laws by closing loopholes by raising the age to buy a semi-automatic weapon from 18 to 21. New York City Mayor Eric Adams said the ruling has made every single one of us less safe from gun violence. From who? The citizens? The law-abiding citizens? And vowed to work to mitigate the damage of the decision. What? It is the criminals, sir. The ones with ill intent are the ones you need to be worried about. Adam goes on to say, and along with New York City Police Commissioner Kitchen Sewell, stressed that the laws remain unchanged in New York for now because the Supreme Court's decision sent the case back to a lower court for implementation. But they both warned the ruling will likely lead to more guns on the street. You mean by law-abiding citizens, you mean. And would change how police and other public safety authorities work in the cities. Because according to you, they're supposed to be the only ones with the guns. For a city like this, densely populated, this decision is just not rooted in reality, he said. This is a city and a country where people have AK-47 assault rifles, multiple shots. I don't know what the Supreme Court was thinking about. Sir, I believe the U.S. Supreme Court was thinking about its law-abiding citizens, sir. Now, what does this mean? Well, for starters, it just dismantled the so-called case of the Dred Scott decision. Look that up, good people. The so-called Black Code's old Jim Crow laws prohibiting free African Americans from purchasing firearms to legally protect themselves. So hats off to Justice Clarence Thomas and the rest of the U.S. Supreme Court, the other 5 who voted for this. You see, this isn't about access to a firearm. It's about the ability to take the firearm with you outside the home to protect yourself. And now a word from those who commented. First commenter wrote, "As a New York City resident and gun owner, I would like to thank Clarence Thomas and the conservatives of the Supreme Court for recognizing our constitutional Second Amendment rights as New Yorkers. But I fear the real fight has only just begun." Maybe. Another commenter wrote, "As a former New Jersey state trooper now living in the right to open carry a firearm state of Texas, good for you, sir. I'm happy as hell for New York. Hopefully this is the first domino to fall for all the liberal states to finally come into line with the rest of the country. I am sure this is a day at the beach for all 2A supporters, Second Amendment supporters, I mean. Once all the legalese and roadblocks are hurdled, there should be nothing stopping black men in good standing to go out and exercise their Second Amendment rights. Chalk one up for Justice Clarence Thomas. It's about time." Another commenter wrote, "I'm not a fan of Clarence Thomas, but as it pertains to the Supreme Court case, flawless." Another commenter wrote, "One thing I think we need to take a look at is how states define their castle doctrines due to retreat laws, especially in New York. In New York, although you have a limited right to stand your ground in your home against bodily harm, outside your home, that right is not as clearly defined. In some counties and cities such as New York City, you have a duty to retreat. I can visualize anti-gun district attorneys and prosecutors using this against lawful concealed carry holders who defend themselves against bodily harm outside their home. It doesn't matter if you have the right to carry if the laws of your state doesn't give you leeway to protect yourself against bodily harm. The burden of proof a respondent concealed carry weapon holder acting in unlawful self-defense needs to be on the state to prove, not the concealed carry holder." Okay, good point. So, there you have it. Let me know what you think about this, good people. Until next time, stay up, stay right, and have a good night.